Provisions of Bail under Code of Criminal Procedure, 1973. Are you a law student or an advocate? Have you ever wondered about the concept of bail under the Code of Criminal Procedure? In this video, we will dive into the intricacies of bail, its significance in criminal cases, and the various provisions that govern it. So, let's get started. What is bail? Bail is essentially the temporary release of an accused individual from custody, with certain conditions imposed, pending their trial or appearance before the court. It serves as a way to ensure the presence of the accused during legal proceedings, while also recognizing their right to liberty. In the Indian legal system, the provisions regarding bail are primarily governed by the Code of Criminal Procedure, commonly known as the CrPC. The CrPC provides detailed guidelines and provisions for granting or denying bail to accused individuals. Types of bail. Under the CrPC, there are generally 4 types of bail: regular bail, default bail, anticipatory bail and interim bail. Let's take a closer look at each of these. 1. Regular bail. Regular bail refers to the bail granted to an individual who is already in custody, either before or after filing a charge sheet against them. When a person is arrested, they have the right to approach the court for bail, unless the offense committed is non-bailable. The court, while granting regular bail, takes various factors into consideration, such as the nature of the offense, the evidence against the accused, the likelihood of the accused absconding, and the possibility of the accused influencing witnesses or tampering with evidence. Additionally, the court may impose certain conditions, like surrendering their passport or regularly reporting to the investigating officer. 2. Default penalties is a right to bail that arises when the police fail to finish an investigation in respect of a person in judicial custody within a certain time frame. It is codified in Section 167(2) of the CrPC.
In Vikramjit Singh v. State of Punjab, 2020, the Supreme Court held that an accused has an inalienable right to default bail if he applies after the stipulated term for investigation.
If an offense has expired but before a charge sheet is submitted. The right to default bail under Section 167(2) of the CrPC is not just a legislative right, it is also part under Article 21. In general, the right to bail on the investigative agency's default is regarded as an unalienable right, although it must be used at the appropriate moment. Regardless of the nature of the offense, default bail is a legal entitlement. The time limit for filing the charge sheet begins on the day the accused is detained for the first time. Section 173 of the CrPC requires a police officer to file a report after completing the appropriate investigation of an offense. In common usage, this report is known as the charge sheet. Section 167(2) a CrPC contains a provision concerning statutory bail. It states that the magistrate may permit the accused person's detention other than in police custody for a period up to 15 days, but not exceeding the period of 90 days if the inquiry relates to an offense punishable by death, life imprisonment, or more than 10 years in prison, and 60 days if the inquiry is about anything else. If the investigation has not been finished after 90 or 60 days, the accused should be released on bail. Nevertheless, the court may set such restrictions when granting bail as the court deems necessary. 3. Anticipatory bail. Anticipatory bail is granted to a person apprehending arrest in a non-bailable offense. It allows the accused to approach the court in advance, seeking protection against arrest. This provision ensures that individuals are not subject to unnecessary arrest, harassment. While granting anticipatory bail, the court examines factors such as the nature and seriousness of the offense, the likelihood of the accused influencing witnesses or tampering with evidence, and the need to balance the rights of the individual with the interest of justice. The court may also impose certain conditions on the accused to ensure their cooperation with the investigation. 4. Interim bail. Interim bail is a temporary bail issued by the court while any application is ongoing or until an anticipatory bail or regular bail application is heard by the court. It is issued as per the requirements of the case. The interim bail time can be prolonged, but if the accused person fails to pay the court for confirmation and/or continuation of the interim bail, his freedom will be lost, and he will be put in jail, or a warrant will be issued against him. This is not the same as anticipatory bail, which is given while the bail application is pending. Interim bail can only aid accused people who believe they have been falsely accused of a crime and wish to get out of jail or on bail as quickly as feasible. Interim bail does not have a separate section in CrPC, but the same restrictions apply in this instance. When a person asks for a regular bail, the court schedules the application after a few days, so that it may review the case diary, which must be received from the police authorities, and the applicant must remain in jail in the interim or following period. Even if the applicant is later freed on bond, his image in society may be irreversibly harmed. A person's reputation is a valued asset and a component of his right under Article 21 of the Constitution. It can be concluded that the authority to grant bail includes the inherent jurisdiction of the concerned court to grant interim release of person until the ultimate disposition of the bail application. Although granting interim bail is at the discretion of the court, the option exists.
Summarization of the provisions related to bail under the CR.P.C.
The CrPC lays down various provisions regarding bail, ensuring a fair and just process. Let's take a closer look at some of the key provisions.
Section 437. Bail and bailable offenses. Section 437 of the CrPC deals with the grant of bail and bailable offenses.
Bailable offenses are those where the accused has the right to be released on bail as a matter of routine, without having to approach the court. The police have the authority to grant bail for bailable offenses. However, there are exceptional circumstances where the police may refuse bail, such as when they have reason to believe that the accused may abscond or when it is necessary for further investigation. Section 439, Special Powers of High Court and Court of Session. Section 439 of the CrPC empowers the High Court and the Court of Sessions to grant bail in non-bailable offences. These courts have the discretion to grant bail based on various factors, as discussed earlier. While exercising their powers, the courts consider the following aspects: A. Nature of the offence. B. The evidence against the accused. C. The stage of the investigation. D. The character and antecedents of the accused. E. The possibility of the accused fleeing from justice. The courts also take into account the rights of the victim and the interest of society while deciding on bail applications. Section 438, Anticipatory Bail. Section 438 of the CrPC deals with anticipatory bail. It allows individuals to approach the court seeking protection against arrest in anticipation of being implicated in a non-bailable offence. The court considers factors such as: A. Gravity of the offence. B. The role of the accused. C. The likelihood of the accused absconding or tampering with evidence. D. The need to balance individual rights with the interest of justice. Conclusion. Bail under the Code of Criminal Procedure is a crucial aspect of the legal system, ensuring that the accused individuals are not subject to unnecessary detention and harassment. It strikes a balance between the right to liberty and the need to ensure the presence of the accused during legal proceedings. In this video, we explored the concept of bail, its types, and the provisions that govern it under the CrPC. By understanding these provisions, law students and advocates can navigate the complexities surrounding bail and effectively represent their clients. Remember, knowing the law is the first step towards effective advocacy.